just introduce myself, and then Ryan can do his own bio, and then we'll get started. So I'm Nita Rizzi. I'm a corporate partner at Taylor English. I started out my practice doing regulation in New York and London. That was not as sexy as it sounded, but I was 2 times for that. I was moved to Atlanta and started doing general corporate and M&A work. So for the past 5 years, my bread and butter has really been traditional M&A, whereas Brian's been focused on ESOP and M&A. So he'll take you through that experience.
Sure. I have, I'm Ryan Owens. I'm partner with Taylor English. I started the firm back in 2018. Let's see. I spent most of my career in a house, actually, as a chief legal officer or general counsel. I kind of came back. Came back into private practice with Taylor English in 2018, and frankly, I just absolutely love the people there. The partner I work with is great. And that's really when I got started in the ESOPs. Earlier in my career, I have worked, and I've actually also been an investor in startups and emerging growth companies. And I sort of came out into the legal industry. For those of you who are old enough to remember the .com era, I was in the aftermath of that. And raised hands. And, you know, it was a great time to come out. I mean, e-commerce was, AI supposed to be the day, it was e-commerce back then, and the internet was fairly new, and it was just amazing how going into these corporate practice, how many of these ideas were really turning into kind of amazing businesses, and I sort of planted the bug with me. So I volunteered some time out there, back out there with the office sponsor, and I'm also very honored to be here with you today. My first event at TiE, and appreciate being here.
So I've been to a lot of monthly meetings, so some familiar faces in here. I think, Brian's really going to talk about ESOPs, but I wanted to kind of get in here and talk just a little bit about preparing your business for an exit. I'm talking about the traditional strategies and also just good governance and good housekeeping in your company. And so preparing whether it's an imminent exit or you're thinking sort of 3 to 5 years out. I wanted to take a couple of slides to talk about what we have seen and what we've learned being on the sell side and representing, clients from $100,000 deals to $1 million deals and everything in between. So the first thing that I would say if your exit is imminent is really thinking about the team that you want to build. Depending on the size of your business, you may use some of you, or all of them. You want to make sure that you get buy-in from all of your owners. If you're a solo business, that's great. If you've got more than 2 or more, then if you've got 2 or more, then you really want to think about getting buy-in. We've had several deals where there were a couple of owners, the 2 majority owners, and they wanted to, they were all going to go about selling their business, and there was a third, they were a bit older, and they wanted to exit. There was a third owner who had a minority stake, and he was not excited about the sale. He was supposed to go with the buyer and stay on as CEO. After 2 weeks, roughly 2 weeks before closing, he decided that he wanted $1 million, and he was not ready to sell. And so the buyer basically told the sellers that this was your problem, and you needed to kick in $500,000 each to make to get this going, and then closing it. So making sure that you guys are all on board and on the same page is really, really important. I've got another client right now who is selling his business for $15 million in waste management, and he's doing this all by himself. Nobody in the company knows that he's selling the business, and he is trying to run the business as usual while simultaneously trying to manage, I think, 5 different due diligence requests from the investment bankers, from the accountants who are trying to run QB, from their tax counsel, from the law firm themselves, and there's also a special consultant who's coming in to value the equipment that he's selling. So he just called me earlier today and said, I've got another request list of 75 items. I'm done. I don't want to sell anymore. I can't do it. Tell them like this is over. And it's been 3 weeks. And not even, we just received comments back on the APA, like we haven't seen nothing yet. So it's really important to bring on a key person. Maybe it's 1, maybe it's 2 trusted advisors, people that can help you with the due diligence process. because it can be overwhelming when you're also trying to run this. You know, it depends on the size of your business. Like I said, you may have investment bankers involved, you may have, valuation experts involved to value the business, or buyers running your QOD. You need people to help you with that. Obviously, if you've got a broker involved, they can help you with the due diligence, but it really depends on the broker. We've dealt with several, not all brokers are created equal. You know, some of them think that, oh, I found you a buyer and that's my job done. Some of them, and you know, I'll wait for my commission, and some of them really get into, I mean, we've had excellent brokers who have really gone in and prepared those disclosure schedules for us, and that's really taken you know, some of the work off our plate, and they've been very helpful. And then down to accounts and lawyers, I would say for building that team, obviously you already have lawyers that you engage and you trust them and they can do the M&A work, that's fantastic. But if you are, if they're a solo practitioner, I would just caution you to make sure that they have best practices and understand the nuances of M&A deals. Like Ryan and I do this day in, day out. It's our bread and butter. So we know how the market is trending. We know, you know, what's going on with indemnities. You know, 20 years ago, 10 years ago, it was very different. The caps and limits that you could put in there. Rep and warranty insurance became a really big thing pre-pandemic. That seems to have gone away. But you know, I think it just, you want to make sure that you've got the right team around you, whether it's external third parties or internal.
It's also a team effort on the M&A side when you're not on the law firm. I could never be really a sole practitioner and do M&A because we need a tax guy. I need a ERISA girl. Actually, I guess I call her a guy anyway. But you know, you need all that support from the different specialties. You have people that specialize in patent review and intellectual property. So there are different aspects that come into play because the business is everything. It's the tax, it's the employee, it's the disputes and litigation, it's the insurance, and so you really just need a little piece from a lot of different people to really be able to get those projects.
Yeah, I'll mention this a little bit later, but it's always good to let your accountant lawyer know early before you sign anything and before you share anything. And that kind of goes to the second point about, you know, don't just sign anything that a buyer puts in front of you in terms of an NDA. There's specific language and nuanced language that you should really have a lawyer look at, and then, you know, you can protect yourselves. Because in that situation, you're going to be the one that's handing over all the information, especially if the buyer is a competitor. We've had instances where they looked at everything and really pushed for, you know, sanitized all the customer information. We're dealing with that now with this waste management company. And they said, well, you know, we've handed back APA comments. We really need to see the customer. And I said, well, we've given you all the customer contracts. They're just redacted with name and address. So what more do you need? Why would you need that? Right. So there's a back and forth, like push and pull of what information you give, can't. And they said, well, we're under NDA. And we're like, but you haven't signed a purchase agreement. If you want to sign and close later, that's great. We'll give you the information then. So you know, it's a push and pull, but you just want to make sure that you had a lawyer review your NDA and save those for LOI. But if you know, every good business should have a solid unilateral NDA and a mutual NDA. So if you don't have one, please ask us. We'll just share them together. We have some good forms to share. So for the third point is to get lawyers involved before you sign your LOI. I can't tell you the number of times we have received LOIs that are just insufficient for the deal. I recently, just 2 weeks ago now, I got an LOI that said, this is going to be either a stock sale or an exit sale. That's great. Those are your really only two options for the traditional M&A. Like, and it doesn't tell you anything about the tax implications, right? They can have an account, their account look at it. So everyone's tax implications, depending on whether you're an LLC, S Corp, C Corp, LLC tax is one of those things that you kind of left to do. It really makes a difference. So you want to make sure that the professionals that know your business are helping you along with this sale, get to look at everything and help you negotiate the LOI. And these are just some of the things that I want to point out on LOIs. you know, just saying like this is gonna be a soccer asset deal is not sufficient, unless there's a specific reason, and they lay out what the structure is gonna look like for each one. And then, you know, is the owner gonna stay on? Are they gonna exit? Are they gonna stay on in an employment W-2 capacity? Are they staying on in a 1099 contractor capacity? Are they staying on just for a short transition period? Is that gonna be paid, unpaid? And you don't wanna get too bogged down into details. And it doesn't need to be your definitive agreement, but, you know, you should have enough meat on the bones to make sure that you are happy with the structure, you know what you're gonna do.
If you, a lot of times there's a tendency on the business side to just say, oh, let's get past, I like this guy, let's get past this LOI stage. If it's a really light LOI, sometimes you gotta be a little bit worried about the intentions of the buyer, whether they're really bona fide, whether they're really not thinking it through. I guarantee there are people out there and some kind of sketchy funds out there that will give you an LOI and be like, oh yeah, we totally want to buy your company, and
Yeah, lock you up for a period, right?
Yeah, they'll lock you up
There's
for
no
a period.
shop, right?
It'd be like-
It's out for 90 days or 120 days or whatever.
lock you up, and they'll say, and we want you to download all your information to our website, so our data room, virtual data room, so we can review it, and they'll get that and download it all, and then they're just not really interested anymore. And there's no explanation, and you've just shown them your secret sauce, and you're hoping that that NDA that your lawyers did review for you is gonna be good enough to keep them out of it. And you know, sometimes I think funds will use that more in terms of making investment, when they look at a competitor or someone else in that industry, but they're constantly looking for that kind of, I mean, I've been on the other side, I represented private equity, and you know, there's a value to looking at 10 deals and doing one. And so you want to make sure that there's enough detail, that if they're willing to put the time in at the front end of the LOI and give you, you know, some detail about how their vision for how this deal is going to be structured, that's a good indicator that, you know, they're serious and they're going to move forward.
Yeah, that's a great point. I wrote in big bold letter, leverage. You have leverage at this stage, use it. And so, and then some of the other things are just, you know, listing excluded assets, and this can go both ways. Buyer can tell you, I don't want those 5 trucks, I don't want this, I don't need an asset deal usually. But on the flip side, you can also say, you know, I want my personal vehicle that's in the company's name, I want myself on my computer, I want the art that's in my office, I want all my personal, you know, all that stuff. And then if there's things that you want them to assume, like if they're a lease, you know, we're selling, I'm gonna name them, that we're selling a franchise that sells baked goods, and they have multiple locations. And so we signed finally after a year of back and forth, we signed yesterday. We now have 9 leases to assign before we close. And that's, you know, if you're doing sign and close later, there's reasons for that, but typically we like to do a simultaneous sign and close where you get everything done the day of. But of course, if there are permits and licenses and receipts and things to sign, then you have that live. But those are the kinds of things that you want to make clear in your LOI. Restrictive covenants is another big one, especially if you're staying on. You want to limit that in time, scope, and geography. So like my husband's a physician, and when I looked at his agreement, I said, well, this, you know, the health system that he works for, I was like, you wouldn't be able to work within 50 miles of the plant, which would basically mean you have to move. I was like, well, that's not happening. So let's pare this down. So we did, you know, I think it was like 15 miles, 10 miles from the location that he works in, not from every location that they own or could own in the future. Right, so there's those kinds of nuances that you can negotiate into your LOI. You want to make sure that the definition of the restriction, the definition of your business is also very narrow. Going back to this waste management company, they wanted to do business is waste management services and anything related to or in connection with it. And we said it's going to be roll off services, and that's it. And eventually we got that. But then you have to have a seller to walk away. Otherwise, yeah, you're kind of stuck. And then the last one on this slide is just indemnities and caps. This will save you a lot of time and a lot of your money if you get this done up front. If you set your caps and your limits on indemnities up front, you will not spend thousands of lawyer time and money talking about, we have gone, I think the most I did was 8 or 9 months, just on this one section. And it was, if you just put that in your LOI up front, you don't have to do that on the back end. And these are all these things that I'm going through are all sort of pulled from basic due diligence request lists that you will see if you're selling your business, right? So all of these things, good housekeeping will help you not only answer your due diligence faster and get through the process, but also will help you fill out the disclosure schedules and the purchase agreements and how you disclose things about your business that the buyer wants to know. And those are your reps and warranties that ties to your indemnity. So it's really important that you kind of focus on these kinds of things. If you have, multiple owners, you want to make sure if you're a corporation, you have a shareholders agreement that kind of dictates and governs how everyone's going to behave. Ownership wise, if you're an LLC, it's an operating agreement. You want to have good records of board minutes, formal appointments of your directors and officers. I know for smaller businesses, it's kind of, you don't think about that stuff and it's just the 2 of us, it's fine. But actually 2 is a really dangerous number in a business because if you're at loggerheads, one of you's gotta go. And so you want to make sure you've got buy seller provisions in your shareholders agreement. Cap tables can quickly become very, very messy if you've got multiple owners and lots of transfers, or you bought a business from somebody. Those are the easiest records to kind of let go of. We spend a lot of time recreating cap tables for people. You say they can't find the stock certificates, they sold a business, they were lost in some storage unit. And digitizing this stuff is also really, really key. I think most of you are in tech where that's based, and you probably have already done that. I had a client in Kennesaw, there 2 husband and wife, in their 80s. And they were selling a mom and pop HVAC filtration business that they had built from the ground up, and they were selling it for 12 or 15 million. And I asked them to upload everything to the data room, and they couldn't even figure out a login. So I was like, this isn't gonna happen. I went out to Kennesaw and legit had like a vault that you find in a bank, which are massive wheels that you have to turn. And I went in there and I had to pull everything, every stock certificate they had. I was just 2 of them, but every contract, every bill, every invoice, we had to recreate everything, put it all in order. It was from like the 60s or something. They started this business. We had to have associates scan, paralegal scan it all. It's a lot of work and money. And so you want to, just make sure when you're getting contracts done, you make your fully executed, all the exhibits are in there. And that's one of the questions that we get from buyers about, can we have fully executed copy? Can we have schedule A to this? Can we have, schedule B to this? Like this is missing, that's missing. There's, you go from amendment 4 to amendment 12, where are all the rest? And so just record keeping is just an important thing. I know I'm probably boring for you guys, but for lawyers, let me. Permits and filings, we get a lot of clients that forget to do their annual business registration, and so the state administratively dissolves you. You can't sell a business that way. It's dissolved, and so we gotta get you back into good standing. They're always gonna ask for financial statements. Know your method of accounting. I think most business owners know this, but if you are not GAAP compliant, then they're gonna ask you to list in what ways you are not GAAP compliant. So you should know what your exceptions are. Operating systems, my bakery client does not keep good records, and it's been really difficult to provide reports because half of her orders are not in the system, and so we're having to bill all that. And the taxes, just make sure that you've got clean tax records, you've got the correct election. If you're an S Corp, you don't blown that election. That becomes a really big one, and you end up having to convert to an LLC. Sales tax seems to be a big one. People don't keep records or don't pay sales tax where they're supposed to when they're selling in different states. So the buyer usually has to do an audit and owe that money, and possibly late fees and penalties as well. There are no transfer taxes in Georgia, but we're selling, to a Colorado business right now, and they have a 2.9% sales tax, or transfer tax, sorry, on, tangible assets. So just know if you're buying a business or selling business in another state, just know what those transfer taxes look like. And then there are a lot of COVID relief programs right now, like I've been hearing a lot about employee retention credit, the ERC. So that stays with the taxpayer. So we've been negotiating back and forth whether it's a stock or an asset deal, who gets to keep that. Okay, so intellectual property. If you have intellectual property in your business, please register it. Otherwise, if you only have common law rights to it and it's not protected, we have a fabulous IP team. We'll just plug them for a second. They not only do they, can they file your patent, but we have engineers on staff who will make sure that the patent is written correctly so that you need to take a look at it and actually, look at it from an engineering perspective, and that helps to get it through very quickly. Also copyrights, you do flat fees on trademarks. So if you've got a logo, the strap line, or whatever your trademark branding is, we offer a flat fee on that. Not everything can be protected by a trademark, but sometimes it comes back and it's rejected. But it's definitely worth trying. We had a business that we were buying, and I was running due diligence on the seller, and they had zero assets. They were a digital marketing company, and I was like, they don't have any, inventory. They don't have any equipment. They just. I was like, what are you buying? What are you paying $12 million for? And he was like, oh, their brand, their logo, and their customer. That's all I need. And then contracts. I'd say if you are a contracts heavy business, and you are in a position to offer up your own paper, it is always better to have consistency in your contracts than for you to be the one to control that first draft. So that later on, when a buyer buys your business and says, well, provide me with every single one of your contracts, you say they're all a variation of this template that we have. On occasion, we will accept for really big customers, paper, but by and large, this is what we use. And that just keeps it really easy and simple. Supplier vendors, to make sure that you're, like I said, they're keeping full copies of everything. Employment agreements and consultant agreements, just make sure that you're being careful with classifications of those. The Department of Labor has revised criteria on who is considered a 1099 independent contractor. So just be mindful of classifications and what goes into the offer letters and employment agreements so that you're not sort of cross-plotting what that is. And then leases and financing agreements. For leases, I would just make sure that like I said, this one bakery, she's missing. She has 9 leases. She's probably missing 80% of her amendments. And we just don't know what they say. So we have to go back to the landlord and tell us how it's shown. And it's just been a bit of a nightmare. The buyer has been very, very patient with us, but that's why it took a year, because it's just been such a mess. And the seller has been quite disorganized, and they've been very patient because they really want the business. But the longer you go, the more expensive it gets. So the faster you can wrap things up, the cheaper it is for you. And I think I'm on my last slide. Yeah. Okay. I think we've already talked about restrictive covenants for the owners, but every buyer will ask whether your employees and consultants have restrictive covenants, and they want copies of those. If they have, signed NDAs, if they have signed work for hire agreements, so that if they are creating, work for you, make sure that it belongs to the company and they don't keep that. And then just for classification, I already mentioned. Once you sign your LOI, there's going to be 3 searches that will run on every business, whether the buyer does it or we do it as a seller's employer. An IP search to see what registered trademarks there are, registered IP there is. A lien search to see what liens are on the business and on your assets. And then a litigation search to see if you've got any judgments ordered against you. And that is a third-party cost, so that's just something additional that is not, it's just an additional cost that you'll have with your lawyers, accountants, advisors, brokers. And it's not a whole lot, but it is important to know, we had several sellers who didn't know that they had liens on the business. And so we just had to go back, they opened the line of credit and they closed it years ago and they didn't know that there's still a blanket lien on their assets. We need to get removed, if it hasn't expired in 5 years. And then just miscellaneous, I kind of wanted to mention, just based off of, experiences that we've had with clients. We started to sell a business years ago. And they were young sellers, it's two brothers, and they bought the business like 5 years before. And we're selling it, and halfway through negotiating the APA, we got a letter from the previous owner who said, I have a broker on this business. You were supposed to tell me about the bona fide offer that you got, and you're supposed to let me offer to buy it back. And so we eventually paid him and was happy to let the business go. But, those kinds of things, if you sign those kinds of agreements, if you give everybody a broker, if you give anybody, warranties outside of your ordinary, warranty, if you have indemnity obligations and agreements that you've, given to a customer that's sort of out of the ordinary, those are things that your buyer is going to want to know, and it's better to get ahead of that, rather than bringing it up later. And then just in terms of timeline, from the time you sign your LOI, you're looking at about 30 to 40 days of due diligence, and then another 40 days, right, of negotiation. Could be longer, like a year-long one, but at least, at least I'd say 90 days from start to finish. Yes. That is it. Well, let's get this.
This is fine. This segues into ESOPs. Thank you for that. And by the way, on the NDAs, if you're own a tech company and you don't have that as part of your onboarding process, you should do it. Call that, I should probably just give it to you for free, but you want to have not just the employees signing the NDA, but you want that assignment of inventions. You want the work for hire, like you're in TiE. Never remember what it stands for when I need to. But that's one of the first things that your buyer is going to look for, to make sure that you own all your IP. You want to have it from the day they start, because that captures everything. And it's really a pretty easy thing to do as part of your onboarding process. All right. ESOPs, it's ESOP was referred to earlier. They're referred to in the industry as ESOPs, employee stock ownership plans. I just have to ask, because I know we've got varying degrees. Who has never heard of an ESOP before? It doesn't really, well, that's a terrible question, because then you're embarrassed. Who here has familiarity? How many of them? I know we have a couple. Familiarity with ESOPs. Okay. Well, there's a number of hands. So we're going to go more high level than that, because I know that there's some people here that probably are on the opposite end of that spectrum, and getting some head nods. And it is, so someone once told me it takes 3 times to have it explained to you before it starts to sink in as to what it, because it's a little bit complicated, but and I think that's right. So I apologize if this is your first time. Get 2 more to go. But it's some great benefits to it as an exit strategy, and we're going to talk about that. So just real quick here, when you're looking to sell your company, you've got some options. You can sell to a strategic buyer. That means somebody who's in an industry that is either the same as yours or synergistic to yours. And they're typically going to be an operating company that's going to fold your operations in, or you become a division of them. They're a strategic buyer. A lot of times they're going to come in. A lot of times they're the ones that are going to cut the most. Their synergies are, we already have back office staff, so we're going to lay those off. And and that's not a bad exit. It's not always employee friendly. Financial buyer is going to be something like private equity coming in and saying, we're going to take a majority stake. Or we're going to buy it, all of you. A lot of times they'll buy a majority stake and require the existing sellers to roll over and become minority owners in the existing business moving forward. And that's got some pros and cons. And then sometimes if it's a smaller business, there's a legacy, and maybe a father wants to pass to a son, or a mom to a daughter, or to employees who are good managers for years, and the owner wants to leave, and he wants to arrange it so that his management team can buy in. there's some problems to that because a lot of times family and employees don't have the funds to buy you. So you'll have to get, the company gets a loan or else it's seller financed. And that's not always ideal for a variety of reasons. But it is a way, all these are ways to get some liquidity. But they can lead to some other problems. I think maybe we're going to talk about some of these disadvantages. A lot of times you're not in control of the process. I mean, they're going to tell you you're going to buy this much and it's our way of the highway. If it's private equity, there's not going to be a lot of negotiation. They don't have a model in mind. They're going to say, we're going to want to buy you all, or we're going to buy majority stake. You're not going to find many buyers out there that are willing to buy a minority stake, and give you a little bit of liquidity while allowing you to retain control. There's some limitations on some of those more traditional ways. Also, it just really puts a lot of risk on whether management will stay, whether it's going to be cleaned out, whether there are going to be cuts. If private equity comes in, they're going to want to control. Are they going to want to run it the same way? They're going to buy it with debt, and so your company will get levered with a debt burden that is going to be a burden on that. I could go on. I mean, I represent a private equity fund, so I should be careful, but they'll also take a fee, a management fee. They get paid 6 ways to Sunday. So, there's a disadvantage, but, they also sometimes will pay a pretty nice valuation for your business. So, you want to value all of those, but ESOP is something that should be at least on the table if you're eligible, because it solves some of these issues. Even in a difficult economy, the economics work well because even though debt is involved, you can take a deduction on the principal on bank debt. You have more money because of the way the economics work with taxes. We'll talk about that more here in a minute. The company has more funds available to pay down debt. You don't have to exit right away. You can do it in tranches. You can form an ESOP that you sell to, maybe a third of your company or maybe half your company, and then down the road you can sell the rest. So if you want to stay involved, but you want some liquidity, and also a pretty sure thing down the road that you got a buyer already built in. And an ESOP is a happy minority owner. They are happy to be uninvolved, and we'll talk about what an ESOP is. I know we're not getting into that, but they're happy to be uninvolved and let you run your business. In fact, they want the ESOP wants the business to continue to be run the way you manage it as an owner and with the management team in place. So, those are just words. Let's go to the drawing. I'm a visual person.
No whiteboard?
Yeah, we're gonna ask about that.
Yeah,
I'm a whiteboard guy. So this is a scenario where maybe you don't find the buyer that you want for your goals as a seller. So, and maybe you want to do something good for your employees at the same time. So you can form a trust. This is what an ESOP is. An ESOP is a plan. It's a defined benefit plan, or it's a retirement plan rather. Yeah, it's governed by ERISA, and it's a benefit to employees. It's like a 401k in some ways, because it's a retirement benefit. But instead of cash at retirement, the employees they do get cash at retirement. But what they do is they have an account that's kept by the trust on their behalf that has shares of the company stock that's been allocated to them. So they actually have that an indirect ownership interest through the trust. And the amazing thing is, unlike stock option plans, this is something that all employees get. At a lot of companies where that kind of ownership culture doesn't trickle down past the senior management. In an ESOP, you've got the lowest level employees are eligible to participate. The stock that's the stock that's allocated to them is going to be where we have here. It's typically about 20 to 25 years, so it's over a period of time as the trust meets out a little bit each year. And we'll talk a little bit more about the value to employees in that culture of ownership. But there's more to discuss here because the trust is just a piece of paper, and you form a trust. How does it buy the stock? How does it acquire the stock? And how is that an exit for the shareholders? the company is gonna have to fund it, and so that's usually done with some combination, some combination means company's not likely to have all the cash it needs to buy a seller out. But the company is able to obtain a loan, and a bank financing. Now, we talked about it before, maybe you can obtain a loan, and you can sell to just a few employees or certain employees directly. But the benefit here is, the way it works is because the company is taking the loan from the bank and then it's in turn lending the money to the trust. The trust is, when it pays back the loan, it's pre-tax. So essentially the purchase price is pre-tax dollars. I'm trying to think of the simplest way to break it down. And so it's got there's more horsepower here to repay a loan involving an ESOP trust than it would be if you were just getting a loan directly. If the loan doesn't give the company enough cash to pay the shareholders, then you can make up the difference you could get mezzanine financing, that's private financing, but most frequently what the difference is made up in seller notes, where the shareholders will take some seller financing, they'll take notes back from the company. And without getting too detailed, this is going to be your senior secured lender is going to be a bank. We work with a lot of banks that have special departments that deal with ESOPs. And they will typically allow interest payments to be made on this while the company pays this down. And then once the senior loan is paid off, then the shareholder principal gets paid off. But it's a nice exit for the shareholders because they get some cash and then they get interest on their notes. And the employees get the benefits, and the principal payments on the loan are tax deductible, so that's a more favorable leverage for the company. And if you do a partial, you can follow up with an additional sale to the trust a few years down the line after you pay down some of the debt. Any questions on that? This is this is called a workshop. Your work.
Round two.
You said principal payments, you meant interest payments?
No principal.
Both.
And it's because.
Right, I didn't hear him say interest.
Yeah, oh yeah, no interest. Yeah, in addition to the interest. And the reason would be, yeah, I'm sorry.
What sort of minimum thresholds are you looking to make this viable?
Great question. We got some other ESOP experts in the room. I wonder if they would agree with this, but what we typically say is that you need at least $1 million of EBITDA in 20 employees. So if suddenly you're like, oh man, this was looking good, and it's like, I mean, but anybody looking to exit, you're looking to get to these numbers anyway. So if this is a few years down the road for you, understood. But there are, there could be some play in those numbers. If you're in a tech company with a high multiple, then maybe that million could be lower, or if you had 20 or 18 highly paid employees. But the gist is that there's some transaction costs involved here that are significant and totally justified by the tax savings of the structure. Don't get me wrong. I mean, it's a no-brainer, frankly. If you need some of these other elements, the financial side of this works really well with your tax savings, but you have to have taxes are a percentage of your purchase price, and so you need to have a certain amount of purchase price for it to make sense and to really get for the tax overcome the transaction costs. Let's see here, but in terms of what an ESOP is, I mean, again, our slides aren't really cooperating with this very well. I wish we come back. We might have to come back to this later, but it's a trust and a plan. It's a benefits plan, but it's operated and administered by a trustee. That's going to be an independent trustee that you appoint. We work with several. There's one here that we work with, and they kind of help walk through the process, but their job is to represent the employees. They kind of make sure that the trust is administered on behalf of the employees, and they're going to negotiate the transaction. So as if they're the buyer, they are the buyer. And so there's still going to be all the process that Netta talked about here, where there's due diligence. They're going to hire a lawyer. The company has to hire a lawyer. They're going to have a financial advisor or a valuation firm do a valuation for them and give them a fairness opinion, because they need that safe harbor to show that as a trustee, they were representing the interests of the employees and they didn't overpay for the company. So there's a lot that goes into that, in setting it up. Which is what, drives those transaction costs. Oh, I see your space. Okay, let's see, we're gonna skip some of this. We talked about family business succession planning. I mean, one thing just to point out, if you're looking to gift equity in your company, I don't know how many company owners we have in here, but if you have shares that you would like to gift, there's actually a great opportunity after you do an ESOP. The value of the stock is going to drop temporarily because you're putting debt on the company, and that always reduces the value of the company. But because it's got a powerful repayment engine, because you've got some tax advantages there, you can actually pay that debt pretty quickly. And so the company's going to cover its value as it pays down that debt. And in the interim, you're able to give more shares to families or trusts. We do a lot of that kind of work, and of course, the liquidity out of your estate in cash is helpful for estate planning as well. And then the need for employee retention. We've actually had some of our clients have come to, especially in the construction industry, who come and tell us that they gotta get an ESOP involved, because all they hear about from their employees is how these other contractors in town are employee owned, or their employees owning stock, and why don't they own stock? And yeah, what I said.
No, you said contractors.
Contractors, yeah, competitors.
Competing companies that offer this benefit, and so they want that.
They want it too. Even if you don't, your employees aren't aware of what it is, after a couple of years, or sometimes it takes a couple of years for employees to start getting these statements every year. What is it? They got like how many shares and what's the value? It's not great at first, but as the years go by and the number of shares increases and the value of the company increases, it becomes pretty readily apparent that it could be a significant retirement benefit for them. And with the way not many people can really rely on their 401ks alone these days, especially if you're not at the top echelons of the company. So it's a great tool for adding your 401k to ensure that employees have enough to retire on it. And that's a huge benefit if you want to retain people. It builds loyalty and culture of ownership. So some tax advantages. I got 655. What's my hard stop special?
I'll give you 10 more minutes.
Okay. Anyone else who's still okay, I don't know. These are in no particular order. These tax. But here's one. There's a section of the Internal Revenue Code of 1042, and we do a lot of these in connection with the ESOP. What it does is the sellers of stock to an ESOP are able to take advantage of this code section if they meet certain requirements, and those are the requirements down below. We won't really get into that, but what relying on this code section does is it allows you to reinvest your purchase price, the proceeds of your purchase price, into qualifying other qualifying investments, operating companies, and there are funds set up for the purpose. There's a lot of investment funds. There are people that sell these kind of investments to ensure that you comply with that, and you do it on a tax deferred basis. So the closest thing, and it's for 1031 with respect to real property, it's similar to that.
Can you convert to a C Corp?
You can, yes, and in fact we do. We do all the
It's
time.
very, it's.
Does that start the 3-year clock, or?
It does.
Okay,
Is it a
so it's 3 years from when you convert to a C.
Oh, you mean in terms of?
You said some of us have the stock for 3
No,
years.
I'm sorry. I'm thinking of the 5-year clock. It would re-elect as an S corp.
Yeah,
I'm sorry. Yeah, no, it does not. That won't matter. You're still on your stock. But there are some nuances. There are some details, and again, the company must be a C corporation, so you lose some S corporation status. So if you're doing a partial sale, that's going to have an impact on your distributions to the main shareholders. So there's a lot to consider there, but if you purchase price is $5 million, you've got $5 million to invest, as opposed to $4 million if you're paying capital gains on it. So I mean, that's $1 million of purchase price you get. Now, to be fair, it's not quite $1 million free. It's tax deferred, but that's money we put in investments and it's going to work with. So it's very attractive to a lot of our clients. And we do quite a few of these 1042 transactions. So we talked about this, that the loan payments are fully deductible, both principal and interest, to your point. And, you know, that creates more earnings. There's tax savings that can go towards, you know, paying down debt faster than it otherwise would be able to. And, you know, in 100% owned ESOP, 100% owned ESOP, that corporation is a powerful vehicle. The government's getting nothing. It's just collecting wealth. And, you know, some of our clients that are ESOP owned that have been around for a while, they paid off their bank debt, they've paid off the sellers, and they've been stockpiling money, or they could do acquisitions with that. I mean, there's a great benefit for, that's when the employees really start seeing the value of their investment or the value of the company going up, because you know, it's just such a great advantage. ESOP doesn't pay tax, and you know, that as an S corp, there's no other shareholders that would pay tax either. No, I'm not going to get into those details. I'm only got like 5 minutes. So if this is another advantage, if you are an S corporation and you're concerned that you know, bringing an ESOP in would destroy your S corp status, you know, it's like an institutional investor. It does not. You can maintain an S corp status as long as you're not doing the 1042. You can maintain your S corp status and still have an ESOP as a shareholder, and that is an advantage. If a private equity fund was coming in, that would destroy your S corp status. You'd be a C corp, and you would no longer be able to do distributions to yourself on a tax-free basis, because you're subject to the double taxation. I think most people know the S corp here. Most start off.
So you convert the S to the C
You convert the S to this.
in order to do that.
Well,
If you're doing a 1042.
if you're doing the 1042, or if you're selling the private equity will require you to convert to a C. But if you're just
Or
doing
to a
ESOP,
shell.
Because an S corp can only have individual owners or an ESOP trust. That's an exception, but otherwise it can only be individuals. So if you brought in an institutional investor to be an owner, that would blow their S election, and you would revert into being a C corp and have double taxation. But it's an S corp.
I should have covered that. I'm going too fast. I'm breaking myself. But yes, that's what would blow it, is that you would, you know, if you find an institutional investor, but you can keep it with an escort, with an ESOP. So yeah, we're winding up here. So just sort of employee perspective, I know there's studies out there, and I should really actually get some more of those in our slides, but you know, it really does make a difference. The pride that an owner, that an employee, and it sounds like I'm selling something here, but you know, I've talked to employees. They really do have a pride when they're can tell people that, yeah, well, you know, it's an employee-owned company. You know, we're the employees, we own it. They feel like they're part of the team. They're more invested in the company's growth, and it's not just, you know, what's the minimum I can do for my salary and then go home, or for my wages and go home. It's thinking about, well, wait, we can save the costs here, or you know, here's an opportunity that maybe nobody's looking at. And you get that all the way down to the lowest level employee. It's a fantastic benefit. Rewards long-term employees over time, and you know, with some companies, I mean, it's happened. The janitor millionaire, that's happened.
Yeah.
And you know, I don't want to oversell it because it's not the norm, but you know, most people at that level never have the opportunity. They don't have the chance to be on that equity side. So it's a wonderful benefit, and especially in the day when we've got so much disparity between the top 3% and the rest of us. Let me say it like that. We talked a little bit about the advantages versus private equity. You know, sometimes you go to market and you're just not going to get a good sale price because you're just not finding the right buyers. And maybe they undervalue business. Maybe your business is service oriented and it's based on relationships, and private equity will often discount it for that because they're worried about the founder sticking around. In an ESOP, you know, trustee comes in, they're still going to negotiate, and they're still going to, they can only pay fair market value. They're not allowed by law, and with the fairness, what the valuation company says is fair and fair market value. However, I mean, they can take some things into consideration. I mean, because there's a tax shield there's the fact that management isn't changing. That management is continuing on. Again, the trustee just wants the status quo. They say, hey, we looked at your historicals, we've seen your business plan, you go, you execute. And, you know, they're not gonna, they don't wanna rock the boat, whereas other types of buyers are more likely to rock the boat. And if you roll over money, with a strategic or a private equity fund, you don't know if that rollover investment's really it's gonna be a new company and it's not quite, you know, and you wanna control. That's one of the things sellers love about these most is that they just stay in control of the company even after selling to the ESOP. And it's especially important if you're taking seller financing because you want to be sure it's able to that the business is running the way that you pay your seller wants. Let's see, and we talked about how it's a friendly investor. So I mean, I think with that, we talked about the estate planning opportunities. I'm gonna skip that, and that was an example. And we talked a little about this. There is some ongoing costs. It's not anywhere near what the initial transaction is, but you are going to have to retain the trustee and pay them the annual fee. You get a valuation once a year. Again, these are not going to break the bank, but it's just there's something to think about. Like with a 401k, you want a third-party administrator who is going to dole out the benefits to the employees. You know, so you just have to be prepared to operate just a little differently that way, but it's nothing too major. I think that's it. I think we should open up are there any questions?
All right, guys, we're gonna start doing Q&A. If you have any questions for that, feel free. We got one right here.
Yeah, in this day and age, how important is it to maintain your capital on Carta? Is that what everybody's expecting you to do, or can I still I have it right now on Excel. I'm
Yes.
Yeah,
about
yes,
Carta.
so we have a lot of plans to keep it on Excel, it's not unusual, but the firm actually does offer, a really good discount on Carta, so if you're interested, we're happy to talk to you about that and just plug for them, but it just simplifies everything, and if you've got a lot of shareholders, it depends on how complex the business is, but if you've got multiple shareholders, it will really help you kind of keep everything in one place. It's a platform where you can, you know, do your resolutions, it'll issue stock certificates, if you've got an equity plan, if you've got, you know, warrants. I mean, it's really more for, you know, more than just issuing stock. But yes, if you're a sophisticated business, you know, a sophisticated buyer, the expectation is that you're using some platform to manage.
We're just agree on one up until a certain capitalization threshold, and then we start charging it. But it's also a garbage in and garbage out tool.
Yeah.
So I mean, I've got clients that try to do it. We always have to fix it.
Yeah.
But we do offer a paralegal is really good at this, so you know we do offer discounts to discount rates to kind of help you get it in shape. But at early stages, you might be able to manage it yourself.
You're saying that it's the online version is free up to a certain level.
It's free up to a certain valuation level, and but although the functionality is a little bit limited, you can go online, it'll kind of tell you what it has there. But you know, eventually, it's so much better, especially when you have opt-ins and keep track of all that. And those are really important when you're selling a company. And cap table, if you think about it, it's like a spreadsheet, right? But you know, that's the ownership, and it's the people who claims the ownership. And you know, there are just way too many floating pieces of paper. I told this guy he'd get 3%. 3% of what? You know, so you really want to have it all in one place that is clear and easy to keep track of.
And they help you do like farm and evaluation. So it just kind of keeps you organized, but also they've got other offerings depending on, you know, your financial stuff. The amount of capital you have, but they do offer more than just keeping it captive.
Great, full 98 value, which is super cheap.
Yeah.
Which is important if you do a stock out.
So that.
Other questions?
Somebody has, an employee has a vested stock. They can sell it to somebody else.
Not always.
No, other than ESOPs, right? You're talking about, yeah.
Are you talking about ESOPs or in general?
Yeah, the ESOP. No, it's you cannot, no, it's not controllable in that way. What they do is the trust will keep an account of who's got what shares of the employees. And, this is part of what the third party administrator does. And it will track, how many shares are in your account. And then when you leave the company, you still have that benefit, it only pays out in death and disability and basically when you retire. So I really retirement benefit, but it also pay out though if an ESOP owned company sells, then that happens quite frequently actually, and so then there'll be a benefit that gets paid out in the form of cash to beneficiaries, but the shares themselves stay in the trust. They're not transferable. It's really an economic benefit. There are certain times when the employees can vote their shares. Interestingly, if you have to have a vote of all the employees to do an asset sale of the company, but not if you're selling the stock. Which is why we always structure it to sell the stock, because we don't want to have to go out and get everybody's vote. But we've done that too, and it's actually kind of fun. It's actually kind of fun when everybody in the employee gets to vote on whether they're selling the company. But those are rare circumstances. It's really more of an economic benefit. Other questions?
I got a quick one for estate planning you guys were talking about. So let's say you have a stock in ESOP and the person passes away, a key person who was invested in it passes away. Does the stock is sold back to the company and the money is given to the family? And how does that work from the tax implication side of things?
Actually, yeah, that's about it.
Basically, it.
Just goes to their estate.
Just goes to the next-
Different plans have certain requirements of how quickly they can pay it out. It depends on how the plan is written. ESOP plan itself.
Very well, sir. SCJ consultant. It's Trustee. That's absolutely right. We're actually on the right side for this because there is a repurchase liability that after you mature a little bit in your ESOP, you want to do this every couple of years, where you have your third party administrator do an analysis of how many people you have that are coming up for retirement, how many people are likely to die.
Right.
But what's your liability? What should you have reserved for these types of payouts that you're gonna have to do coming up? Yes.
As far as the trustee for the ESOP, does the firm appoint that trustee, or you mentioned something earlier about you can have your own trustee?
So back in the day, it would be like an officer of the company that would act as trustee, but that's a bad practice today. You really want an independent. So what happens is, so if you can imagine, like if you're the seller and you appoint yourself a trustee, you're basically selling the business to yourself, right? Because you're acting, well, I'm acting on behalf of I'm putting my hat on employees now. Yeah. So the Department of Labor audits these from time to time, and to make sure that you're really, that the trustee is really representing that they're not overpaying, that this is a true benefit to these employees, and not just the way the owners align their pockets with more money than the business is worth. So yeah, you've got the best practice now. We only do ESOP who are independent of the trustee. In fact, I know. Sorry. The best practice, the one that we'll usually do is we'll have the board of directors appoint a separate committee, a trustee selection committee, and we like to comprise that committee of just participants in the plan, not sellers, but just employees. So it's usually management who are non-owners, a couple people, maybe 3 people, 4 people. But it's a committee that will then interview a number of employees, or I'm sorry, a number of trustee candidates, and they'll select one, and they have no idea what they're doing. So we have to tell them, do a lot of education like this, and let them know what it entails and what the purpose of the trustee is, and they'll chime in and they select it, and they select someone they like, and that way it's totally independent of the selling involved. Good question.
And there's trustee fees, and then they hire their own attorney, so there's company attorney, there's trust attorneys, and then.
But yes, that is correct. Yeah.
Is there a potential for a liquidity event for the employees prior to termination of employment?
Yeah, I mean, there is, if there's a sale of the company, and if there's a sale of the company and a termination of the plan, then the benefits can the cap.
So they can't like pass it because they have a family along the way, stuck with it until they quit.
Yeah. I mean, what's that?
And even after.
But they
And even
keep
after we-
vested stock, right? You don't have
That's
to
always
be
the best. Yeah. What's the best? And there are different vesting, you have some different vesting options to do it, and we'll tailor the plan within the confines of ERISA. Don't ask me what that stands for. I don't know what I was told, every ridiculous, like, it's out and something told me, but, you tailor the vesting so that it go to your employees.
Right?
Achieve your goals. Any other questions?
Cool. I'm looking good on the chat too. So.
What's that? All right.
There's no one, no.
Awesome, guys.
Great.
Let's give a round of applause.